Good morning to your listeners.
I am doing well, and I hope you are well too.
Alhamdulillah, I'm okay.
Well, first, let me start by asking what the status of that whole process is. You vetted her, so what happens? Where are we now?
So far as we are concerned, we the minority members, we are at the stage where we have not taken a decision yet on her. And so, like we announced, we're waiting to hear from the Supreme Court on their decision in the question matter, and then we will take a decision afterwards. That's where we are now. But then the chairman of the committee, if I may, with all due respect, in clear violation of good faith, has gone ahead to announce that the majority side have approved him by a majority decision. And I say, with all due respect, because you all witnessed the proceedings, and you recall that I specifically said I was not going to ask the nominee any question because I was waiting for the ruling in the question matter, and after that I will have the opportunity to ask her all the questions. And the chairman, and I said that it was based on an understanding that I was told had been reached between the leaders, that is the chairman, and our leader, who is the ranking member on the committee. And you watched the proceedings. The man did not there and then dispute what I had said. He did not challenge what I had said. He did not insist that I should ask my questions there because he will not give or afford an opportunity to have the lady recalled again for further questioning. I'm sure you remember.
Yes, I do.
So he did not. So clearly, at that moment, he endorsed my position that at a subsequent date, she will be recalled to come and answer additional questions. So to wait, and then after we had closed and the cameras left, and it was just us members of the committee, for you to turn around and say, oh, so far as you are concerned, every opportunity was afforded for her to be questioned, and we were the ones who refused to do the questioning, smacks of bad faith, bad leadership, and going forward, it's difficult to work with a person like that. So for me, whether he will recall her or not, because he is chairman of the committee and he thinks that he can use his power arbitrarily, will be a reflection on his own character as a leader. But clearly I communicated to everybody that I wasn't going to question her because all my questions are going to be focused on the question case. And because I'm not a chairman or ranking, I have only 3 shots at asking questions. And I don't know the kind of complications that will arise in the ruling in the question case. So I might need all those 3 opportunities to be able to interrogate the jurisprudence that will inform that case. And that is why I reserved all my 3 chances. If he says there is no chance, it's up to him as a chairman. But when the question matter is determined and we all read the judgment, we'll all be able to further, evaluate the jurisprudence that will inform the attitude of the new Chief Justice when she is approved. Otherwise, as a minority, in all fairness, we've looked at her CV, we've looked at her work, we've listened to her largely. Some of our colleagues asked her questions. We don't have an issue with her competence in certain respects, but we have some reservations about the jurisprudence that she's bringing on board, and we want to use this last opportunity because it raises very complex, interesting constitutional issues we want to see her approach to resolving those constitutional issues.
And first, let me take a step back. Are you saying that you had an agreement with the chairman on the committee that there will be time for those questions? They'll give an opportunity for you to ask questions after that judgment was out?
Exactly. That was what we were told by our leader, because we refused to participate in proceedings until the question matter was determined. Then our leader went to inform them that this is the stand of the minority, that we will not participate until we hear the question matter. And then they engaged, and as a compromise, the understanding was that we should come and then participate, and then after we have participated, and then at a later date, after the judgment, she will be recalled again for us to ask our questions in relation to the judgment, and then we'll complete the process. So they came back and informed us. So when they informed us, we said, okay, if we'll be given an opportunity to question her on the question matter, and since they have already assembled and they are in the hall waiting, let's go and participate. And then when the question matter is decided, we'll have another bite. That is why when we entered, our leader in his opening made that point. And then when it got to my turn, I decided to further buttress it by actually refusing to ask questions, and to say that I was refusing to ask because there is an opportunity for us again to engage her as a committee. And the chairman did not, at that point, deny that there was such an understanding. If he had denied that there was such an understanding there and then I would have concluded that our leaders probably did not convey to us the full sense of the position that they had reached as leaders. But he kept quiet, and that implied that he agreed with the report that I presented. So, as I said, it's all a reflection on the quality and character of his leadership.
But you also say you have a problem with the jurisprudential direction that the Chief Justice the nominee might bring to the judiciary if she is approved. What's your concern?
I'm saying that there is another opportunity for us to further assess her and the jurisprudence that she might bring to the work that she will do. And that is how she approaches the question decision. She has already, don't forget that she has already, announced the decision. So the issue now is not the decision, whether or not question is disqualified. The issue is how she justifies the decision. And that is where we'll have an insight into her jurisprudence. How does she justify that decision? Because there are complicated questions of, whether or not the determining time should be when he filed or when Parliament was sworn in. Those are major jurisprudential questions and issues that need to be resolved. And they've taken a position. So we want to hear, how is the reason? What is it? How did they come to that conclusion? What kind of jurisprudence, is she going to deploy? Those are qualitative matters in terms of, the way she reasons and thinks and etc. She said that she is a textualist. If you remember, when we asked her what is her attitude towards constitutional interpretation, and she said, "Oh, I'm a textualist." So a textualist, basically is somebody who follows closely what the text of the Constitution says, and with very little regard for the context. The fact that we are living in a world where there's a changing context in which we must apply the same text to. So a text that was, developed in the early 90s, 1991 up to 1992, which was enacted in 1992. And then today we are in 2023. In future, we'll be going into 4 or 5 decades after the text was enacted. The world is changing a lot. Issues of citizenship have, become interesting ones with people, what we call global citizens emerging. And countries are mobilizing and utilizing all the available human resource, whether locally located or, located abroad. We have changed our tax legislation so that whether you live in Ghana or you work, you earn income abroad, once you are a citizen of Ghana, you pay tax irrespective of where you earn the income. So if I go and work in America and earn income, unless the law of double taxation applies, I may have to account for my earnings. So with all these new developments, what is the political bargain in relation to dual nationals participation in our governance, and what leeway do we have to mobilize competence abroad for our human resource capacity build-up? These are critical questions that must also apply to context. And so I am interested in the way that the Supreme Court, reasons in the light of these new changes and development. That is what we mean by understanding the attitude and jurisprudence that a judge or a Supreme Court led by her will bring to the problems and challenges that will confront us in the future. She might be a Chief Justice for the next decade. How will the next decade portend for us in terms of the role of the Supreme Court in directing the country going forward? Don't forget that the Supreme Court is also our constitutional court. It is an ordinary appellate court, but it is also a constitutional court. And all over the world, constitutional courts by nature have a very crucial political role in the direction of a country.
So you wouldn't get that opportunity, clearly, from what the chairman has said?
Yes, it will depend on the ruling. If the ruling doesn't really provoke critical jurisprudential questions, I will not mind, in all sincerity. I'm not out there just to obstruct the appointment of a Chief Justice and create a constitutional crisis for the country when a certain Chief Justice has retired and there's a vacuum. But at the same time, I will not renege on my responsibility to critically examine quality before I endorse it.
No, I'm asking that because it looks like you have the opportunity through the appointments committee, if the chairman has already announced that they have approved by a majority decision, which means it goes back to the House, does it not?
It goes back to the House, but there's a danger there. They are taking a risk because we haven't taken a decision that she should go through voting. But if they decide to approach it that way and they are unyielding in the engagement between us and she has to be taken through voting, it's a big risk to her. So it's up to them. We have left it open and said, look, as for us, when we get the judgment, and from our analysis of the judgment, there are outstanding questions, we will answer those questions. If you refuse to give us the opportunity to answer those questions, then you will be the one, dragging her to the floor for voting. We may ask those questions and finish and say, yeah, we endorse you, go ahead. So it's up to you to decide whether you want to give us the opportunity or not. We may also see the judgment, analyze it, and most lawyers will agree that the judgment makes sense, and so we should leave it there. So if most lawyers look at it, including myself as a lawyer, And I think that it makes some sense, and therefore I should leave it there. Then I may not need us to labor inviting everybody to come back again, and then the whole world to come and sit and observe me, ask questions that may not be necessary.
So at this point, until that judgment is out, if the judgment, and I wanted to find out, when are you returning to Parliament?
In fact, that was one of the issues. Parliament is resuming on the 6th, and the judgment is coming in on the 7th. So, in fact, most members of, all the members on our side, and indeed, a number of people on their side, said that it made sense to give us up to the 7th to communicate to them our decision. Because, in any case, she cannot be approved before the 6th. And what is the difference between the 6th and the 7th? So given that there's no material time difference between the 6th and the 7th, some people on her side, on his side, the chairman's side, really thought that, our colleagues say they want up to 7 to take a decision. Let's give them up to 7. In any case, we can't go send a report to Parliament before that day. So since we cannot send a report to Parliament before that day, why are we in a hurry to say that we have concluded on a report? So there were people on his side who agreed with us. But the chairman was so, obstinate in his position that, so far as he's concerned, every opportunity has been given. And some people felt, look, you are just endangering this nominee because they haven't said they will not approve her. They've simply said, give us additional time, which time for us doesn't cost us much because in any case, we can't do anything with her before that time. And he just refused. So, we're waiting to see how it plays out.
So it is likely that if that comes on the June 6th, you've not had the opportunity of seeing the judgment, there might be a decision by the minority to either oppose or abstain from the approval process.
I don't have the authority of my leader to respond to that. He said that we haven't taken a decision yet. He will direct how we operate.
But this morning, Honorable Ayariga, we've also been talking about this issue because one of the questions that was asked, I know you didn't ask this question, but it was asked by your whip, who was asking the question about the matter of birth certificates. A lot of my listeners have constantly been sending messages since that decision was made back then in 2020. And listening to her try to justify it again brings back those memories of those questions, and the questions then started coming back. When you listen, what came to mind? I even thought that in her response, she kind of contradicted the Supreme Court position. If you listen closely to her, I think that towards the end of the engagement with the whip, she kind of agreed that the birth certificate can be a document to be used in proving citizenship. But the birth certificate itself does not prove the citizenship. If you recall, you can play the interview. Are you listening? Yes, I'm listening carefully.
Yes, if you play the interview, my sense or my take was that towards the end, she seemed to have agreed with us that the birth certificate can be used to prove citizenship, but that the birth certificate itself is not the evidence of the citizenship. Okay. But that is all that we have been saying over the years about the Supreme Court ruling, that there are a number of documents that you can use to prove citizenship, because like she herself did the analysis, it is about your lineage. Who is your father, and who is your mother, and who is your grandfather, and who is your grandmother, your lineage. And what was their nationality at the time of your birth. And she agreed that on the birth certificate form, there is information regarding the name and identity of parents, and there is information regarding the nationality of parents, and therefore you can use the information there to prove it but the certificate itself is not the evidence of the citizenship. But that's all we have been saying. That look, allow people who go to National Identification Authority and try to prove their citizenship to use the birth certificate and the information on it as information that can be used to deduce whether or not they are citizens. Because all that the National Identification Authority is asking is, were you born by a Ghanaian parent or parents? Were you born either in Ghana or abroad? Those are the two critical questions that will help them to determine whether you are a citizen or not. So if there is information on your birth certificate that helps them to answer these questions, what logic do you have to say that no Ghanaian can present his birth certificate to aid him or her to prove the evidence of his citizenship derived from the fact that his mother or father at the time of his birth were citizens? Play the recordings closely, and I think that she ended up actually giving the Supreme Court out.
And that's the confusion here, because the Supreme Court is definite that you can't use it.
And yet she, who I think was part of the bench, if you recall, now thinks or implies otherwise. I just want you to play the tape and listen closely and see whether I am right in my judgment that she kind of, towards the end, agreed that the information on the birth certificate, if it aids to prove the nationality and the identity of a parent, can be useful in helping to establish the nationality of an applicant for national identification card registration.
But which one should stand, her explanation or that of the Supreme Court?
That of the Supreme Court, but then it just shows how she could easily, break down under interrogation, and also it then, further gives you ammunition to question her consistency as, a person to lead the Supreme Court of Ghana. That is why we think that, a complex case like, the question matter will further give us a window into the way she thinks and how and what kind of Supreme Court we should expect under her leadership.
But for the average Ghanaian, the question that has come back this morning on the matter of the birth certificate is, what do I use the birth certificate for? What value does it?
What the Supreme Court has said. She alone sitting during an interrogation and saying something does not change the decision of the Supreme Court.
Because I was also reading a visa application that was denied on the basis of the fact that we are even saying it cannot be adequate proof.
Exactly. So it just means the Supreme Court is messed us up, and so we should be worried about the quality of reasoning, and that is why we thought that beyond a beautiful CV and the wealth of experience that she appears to have, having served as a High Court judge, as a Court of Appeal judge, and as a Supreme Court judge. Beyond that wealth of experience, we should be also paying attention to the quality of her jurisprudence.
Honorable, thank you very much for speaking to us this morning.
I hope I haven't confused you further, since you say our listeners are confused.
I think where you said the Supreme Court has messed us up, that explains the difficulty we have currently with that judgment.
So, I've never agreed with that judgment. I've been consistent that I've never agreed with them. I think that is the most retrogressive ruling that can come around, because I do agree with them that the certificate itself is not necessarily the evidence, but a certificate can be admitted by the National Identification Authority to assist and prove your nationality and recommend
Honorable, we are losing you.
Yeah, I'm saying that. Can you hear me now?
Yes, it's better.
Yeah, I'm saying that I have been consistent in my disapproval of that decision. So, I'm not surprised that Ghanaians are equally confused.
Honorable, thank you. And I hope we will have the opportunity of speaking when you see the Jechi Kwesi decision.
No, definitely. I believe that when the Justice Kwesi decision is handed, the reasoning becomes public. We will all have an opportunity to engage on it. So that I can assure you will happen in this republic. We hear each other on the matter.
Thank you. I wish you all the best.
Thank you.
Yeah, this is Honorable Mahama Ayariga, who is Member of Parliament for Boku Central, a member of the Appointments Committee.